Would already be loss of energy at that point, my lady.
And then it's not in dispute that that bullet ricocheted or deflected to F, where there's some serious damage caused.
That is correct, my lady.
Now, when it impacts at F, causing the tiles to break, what would have been the case with the energy of the bullet, the remaining energy?
Well, my lady, a lot of the energy, or the most of the energy, will be lost at that point. And then it only rebounded and fell into the toilet with a piece of tile.
Well, joining me now is former High Court Judge Chris Greenland, a regular guest on Channel 199. Thank you for joining us as always.
Good afternoon, Bongani.
Before we even get to today, I mean, isn't it one of the rules that lawyers don't bring to court witnesses whose testimony they can't predict, whose answers they don't know? Let's go back to yesterday. How was it that a surprise witness came along 72 hours after she'd first approached the defense to try and testify on what she observed of Oscar Pistorius in the hours following his arrest?
Bongani, you referring to Van Schalkwyk?
Of course, yes.
Well, I would say, in terms of my reaction, I'm dumbfounded, I'm confounded, and I'm bemused, in fact, gobsmacked, because I've thought about it, and in my respectful opinion, all her evidence was inadmissible. Firstly, because she was deposing to Oscar's emotional and psychological condition. Was that relevant? Was it an issue that was relevant in the determination of whether Oscar is guilty or not? And as to his state of mind at the time of shooting, that's highly problematical. His condition a day after the shooting is of very, very little probative value. So that's the first point. Secondly, she was giving opinion. She was giving her opinions. And your viewers now are all experts on this. They all know that only expert witnesses who are qualified, in other words, they prove their qualifications in court and the court accepts that they're experts, can proffer opinion, their opinions in a court of law. She was not an expert in psychology and emotional condition. And thirdly, she was deposing to hearsay. Hearsay is when I come to court and say, oh, Bongani told me this and so told me that. That is not permissible unless what Bongani told me is already before the court.
Well, let me ask you this then, Judge. I mean, it was Judge Masipa who, when Kerinel objected pretty much, as I understood his argument, along the lines of what you're now saying. Yeah. But she said, well, hang on, you opened that door when you challenged the accused on his emotions, when you said, but aren't you using your emotions now to avoid questions?
That's problematical. I don't think it can be said that Kerinel ever put it to Oscar Pistorius that one day after the shooting, you were unemotional. I certainly have not picked that up. So I don't think that that is an acceptable reason. But just to follow through on this business of hearsay, you see, if Oscar, and we know Oscar was not led, he never gave this evidence. He never gave evidence to the court that the day after the shooting, I met up with Van Schalkwyk and I said this to her and I said that to her. Because if he had tried to do that, the court would have said, no, you can't come to court and tell us what you told people. So he would not have been allowed to do that. So it's highly problematical that she then is allowed to give this evidence.
All right, let's fast forward then to today. Wally Wolmarans has been, billed by many as a star expert witness for the defense, and may in fact have said that for the defense's case, he's almost certainly the second most important of their witnesses after the accused himself. Are they getting, bang for their buck, so to speak?
Fortunately, I don't know Wolmarans. I've never seen him before, so I see him from a completely independent and new perspective. Of what I saw of him, he seemed to be struggling. And I think that he should not be giving evidence in English. So I think that there was a difficulty there. But the more important concern I have is two things. the fact that he was prepared to take another witness who had given evidence and go and have a drink with him immediately after he had given his evidence, that was Roger Dixon. And
he came to his house. He might have popped in at my house to say, how's it?
This association, the timing is very unfortunate between these two witnesses. I don't think Wolmarans, with all his experience, he should have known better. And also, and perhaps more importantly, the timing of his expert report coming in April, a month after Mangena had given evidence, and resulting in a situation, and you'll have to correct me if I'm wrong, because I wasn't able to watch all his evidence, resulting in a situation where his evidence was therefore not put to Mangena. I think this all creates a sort of odor, the pungency of which now we can speculate on.
Well, so what does the court make of it? Because one of the issues, or at least the difficulty he had in, for example, admitting that he'd submitted written reports to the defense prior to this final one on the 23rd of April, is that obviously he would now have to produce them. So what does the court make of this apparent lapse, I suppose, whether it's, proper record keeping and actually having reports to refer to, and this exact idea that you've just brought up, that he would actually be speaking to another witness?
Well, the court will be influenced by his explanations. I'm sure that he's getting a real pasting from Gerinel on this. So the court will look at his explanations. But I think one has to accept that as a starting point, the court will be uncomfortable with that. And it'll want reassuring, clear, convincing explanations as regards all these aspects.
But surely as an expert witness, one of the things you would be very aware of is to avoid anything that would cast doubt in terms of your process. I mean, this is one, it's said to be, he's one of the most, he's one of the most foremost experts in this field, and yet simple things like the earliest reports are things he can't remember.
Yes, and he even has an admirable international reputation. And yes, I heard him protesting, saying that he takes exception to Gerinel putting his integrity in issue. And you're quite right, Bongani. For those very reasons, he should present like Caesar's wife, above reproach.
So, I mean, where does this all leave the defense then? Because even on some of the key issues, there was that issue around the magazine rack. He's being shown evidence in court where the defense has maintained that the bullet that Captain Mangena said had ricocheted and hit Reeva Steenkamp on the back, they've maintained it didn't do so. It fell into the toilet, they've argued. Now he's shown, a match, or what looks like a match between the bullet and the actual mark on the body of the deceased, and all he can say is that it was probably caused by the magazine rack, but then concedes it's too smooth to be the only factor.
Bongani, I think my approach to this expert evidence is that it's all very interesting. These disputes and arguments and technical points that are being scored are very, very interesting. But to what extent do they assist the court on the issue of Oscar's state of mind when he pulled the trigger 4 times? And secondly, to what extent can these differing opinions contradict the direct evidence of 2 sets of independent witnesses, Michelle Berger and her husband, and I think the Stips, who said they heard Reeva scream.
Oh, a woman scream.
A woman scream. Well, it could have, okay, yes, a woman scream. So, and that to me is what's problematical for the defense.
What about the explanation that the lawyers have been giving us about possibly reasonably true? I mean, does the court not weigh up what the defense is saying and accept it as an alternate explanation, even if that one is more convincing?
Yes, my colleagues have trotted this out repeatedly, quite understandably, and technically they're correct. But the public must not have the impression that what happens is that I shoot you, and then provided I serve up some story that might possibly reasonably be true, that's all I need to do to get off responsibility for killing you. It's not that simple. I have said this before, on these facts, where Oscar has had to admit that he shot Riva in circumstances where he pulled the trigger 4 times, he has to convince that court that that killing was legally excusable. And for all practical purposes, the court, and that's the whole of the court, the judge and the 2 assessors, have to believe him. If they don't believe him, if they disbelieve him, he will be held accountable. He'll be found guilty of murder at worst, and at the very least of culpable homicide. In other words, they'll say, well, you created some doubt about your intention. This was overreaction, but it was still unlawful killing, and you'd be found guilty of culpable homicide. But in effect, Oscar has to talk his way out of this one.
Well, the difficulty, I suppose, about the believability is we've now had 2 of the defense's expert witnesses contradict at least one aspect of his testimony, and quite forcefully so. Judge Greenland, as always, it's fascinating to talk to you. You always contextualize these things in a way that's very accessible for us. Thank you for joining us.
It's a pleasure. Thank you.
All right, we'll look at some social media soon, but before we go there, here are some more highlights.
Can you explain it with reference to this photo, Mr. Wolmarans?
Come again.
Can you explain it with reference to this photograph?
Yes.
If the deceased was now, as Captain Mangena testified, sitting on the magazine rack, and you take point E, F to E, and then to the back of the deceased, how would that align? You say it would not align. Can you explain it?
It's difficult, my lady, but as I said, it would have been a skeins from the left to the right.
Demonstrate on the photo there.
It came from the left to the right, my lady. And from the right to the left. And not in a straight line. I don't know how it came. That doesn't make sense to me.
Paragraph 36.4.
B4A. This is a fragmented jacket which has 3 grooves. The fragmented jacket weighs.
Hold on.
Which paragraph are you at, Mr. Wolmarans?
I'm lost.
Sorry, I'm lost.
Where exactly are we now?
37.
37. Yes. 37.16.
I apologize, man. I realized that. It's 37.16, page 34.
37.16.
Yes.
The wounds to the back were caused by a fragment. The fragment would have damaged the fabric of the vest, and there is no such damage. The wounds are also inconsistent with wounds caused by a fragment of this type of ammunition. According to Captain Mangena's evidence, with the bullet which hit points E and F, ricocheted from F, and caused the injuries to the back of the deceased at the time that she was seated on the magazine rack cannot be correct. The only reasonable manner in which the injuries to the back of the deceased could have been caused was when the deceased was falling, probably during the firing of the shots, and her back came in contact with a hard surface, which could only have been the magazine rack. This accords with one.